As it turns out, our human rights are under threat from multiple directions, and I'm going to tell you about 3 of them. Hi there, my name is Michiel, and this is We Can Do Better. Last week I published my first episode on the channel. It's about a potential new human right. That right is called cognitive liberty, and in the episode I explain what it is and why we need it. If you haven't seen it yet, go check it out right here. When I was researching the episode, I learned a lot of new things, but not everything was relevant, so I decided to make a second series, the one you're watching right now. The series acts as a sort of companion series. Each week I pick out a subject which is only tangentially related to the main episode. It's also supposed to be a little more informal, but we'll see how that goes. We will be focusing on the United Nations Declaration of Human Rights and the European Convention on Human Rights. Let's start with the first. The United Nations was founded almost immediately after the Second World War in 1945 to prevent future world wars. After the full extent of the horrors inflicted by Nazi Germany came to light, the Universal Declaration of Human Rights, the UDHR, was adopted in 1948. A year later, in 1949, the Council of Europe was founded with the same intention. The European Convention on Human Rights, the ECHR, was drafted and entered into force in 1953. The ECTHR, the European Court on Human Rights, was founded to rule on any supposed violations of these rights. So, with that out of the way, we can finally get to the 3 ways in which our rights are being threatened. The first threat is the legal doctrine of the margin of appreciation, also, and more descriptively called the margin of state discretion. Simply put, the European Court of Human Rights has to take into account national laws when determining if a violation of human rights has occurred, as well as if there is a general consensus on the subject. While I do not deny that in some instances the doctrine is applicable, I was constantly frustrated by the application of this principle. The reason is simple. Take Article 14 of the ECHR for example, the right against discrimination. It adds a nice or other status to its list of protections, but in practice this means that the right is only protected if there is a general consensus and if the state's law does not explicitly deny protection to the right. Let me give you a few examples. In 2010, the ECTHR ruled that an Austrian same-sex couple did not have the right to marry. In 2010. Let that sink in. To show how general opinion affects the interpretation of the ECHR, in 1986, the ruling by a court in the United Kingdom denying a transgender person the right to change their sex on their birth certificate and passport was upheld by the ECTHR, which ruled that it did not constitute discrimination. According to the court's ruling, a fair balance must be struck between the interests of the community and the interests of the individual, and that it could place no impossible or disproportionate burden on the authorities. However, 16 years later, in 2002, the court found that the same charge did constitute discrimination and was not within the state's margin of appreciation. So the question is, did the definition of discrimination change, or did public opinion? If it's the first, then the concept of discrimination is useless. If it's the second, then the right against discrimination is useless. To be clear, I don't think we should never change our minds. What I am saying is that the 1986 ruling was incorrect, as reality hasn't changed. Only public opinion has. The addition of any other status is not up for interpretation, yet that seems to be what has happened. Other examples come from France. In at least 2 instances, students were expelled from the schools because they refused to remove their religious headwear during physical education. In the first case, the ECTHR ruled that the expulsion did not constitute a violation of freedom of religion. The student was a Muslim woman, so no surprise there. Anti-Muslim sentiment is shockingly commonplace, especially in France. In the second instance, the student wore a keski, a type of turban. The ECTHR said that the National Court had balanced competing interests correctly. However, in an interesting turn of events, the case was then brought before the United Nations Human Rights Council, which found that the expulsion did violate freedom of religion and freedom to express religion. While this ruling was based on the Universal Declaration of Human Rights instead of the ECHR, the sentiment expressed in the relevant articles is identical. So how can these rights, which are supposed to be universal, differ between courts? If these rights can be interpreted based on public opinion at the time, and if different courts can come to different conclusions, Then what exactly is the point? In these cases, and many others like them, the margin of appreciation is just a loophole for states to continue to violate human rights without being held accountable for it. The second reason why human rights are being threatened is the concept of so-called rights inflation. This oddly economic sounding term is meant to criticize the increasing numbers of rights claimed and with that the broader applicability of existing rights. While these critics are usually fine with civic and political rights such as freedom of religion, in principle at least, they are critical of social and economic rights such as the right to health care. Rights which support or do not challenge commodification and market freedom are seen as real rights, while rights that imply or necessitate transformation are seen as false rights. This is nothing more than a neoliberal objection to interference with the free market. This kind of boundary drawing places issues or people either inside or outside the law, as has historically been done to marginalized communities and is still in full force today. Also, these critics ignore the fact that new rights are rarely argued for. In most cases, as we have seen earlier in this video, when a 16-year time span changed the opinion about discrimination of transgender persons, existing rights are reinterpreted and applied to newly acknowledged realities. A final example comes from the United States. In 2018, the State Department hosted the Ministerial to Advance Religious Freedom. Since this is America we're talking about, you can see where this is going. Christian conservative attorney Benjamin Bull claimed that the left was using newly manufactured rights, an apparent reference to LGBTQIA+ related rights, to crush the traditional and natural rights recognized by Christians. The Commission on Unalienable Rights was established by then Secretary of State Mike Pompeo in 2019 with the goal of combating these manufactured rights. I was very happy to read that in May 2020, 167 rights advocates and organizations put out a statement expressing grave concern about the direction of the Commission and urged it to reject the prioritization of freedom of religion as a cloak to permit violations of the human rights of women, girls, lesbian, gay, bisexual and transgender people. I was even happier to read that Miguel H. Diaz, former ambassador to the Holy See, joined by 125 Catholic theologians and leaders, signed a public petition which expressed concern that the Commission was poised to lead to policies that would harm people who are already vulnerable, especially poor women, children, LGBTI people, refugees, immigrants and those in need of reproductive health services. And I was overjoyed when I read that Brian Messengale, the James and Nancy Buckham Chair in Applied Christian Ethics at Fordham University, added, to undermine the conviction that all human beings, created in the image of God, possess inherent rights to life and liberty is both disturbing as an American and offensive as a Christian. Funnily enough, these religious people express the same concerns as me. It's not often that I agree with Christians or followers of any religion for that matter. The Commission released its final report in August 2020. So that was that. Finally, the third threat comes from authoritarian politicians and those of us who vote them in power. The goals of politicians are to preserve and consolidate political power. The aim of the political rights movement is to hold those in power accountable for the way they use that power. Because of the nature of popular elections, politicians need a numerical majority in order to get and hold on to power. Human rights activists are concerned with the rights of all, especially disadvantaged minorities which are so often disregarded, overridden or outright persecuted by the majority. In the United States, the civil rights movement of the 1960s and 70s paved the way for more recent movements such as Black Lives Matter in fighting the broad range of manifestations of white supremacy in law and society in the United States, Europe and abroad. Most criticisms against human rights I have found are full of fallacies and they use thought-terminating rhetoric in order to prevent anyone from imagining a better world where the rights of everyone to live a dignified life are fully guaranteed. Interpretations based on prevailing opinion undermines the entire point of human rights. And religious extremists use the language of human rights, in particular freedom of religion and freedom of speech, to oppose any and all rights that aim to protect marginalized groups, however slight and imperfect these rights will be in practice. I just get so damn furious by all this progress slowing bullshit. So that's it. I'm done. Rant over. I'm curious to know what you think. Let me know in the comments. If you like this video, don't forget to like and subscribe. I will publish a new video of your regularly scheduled episode on Monday and the accompanying Somewhere Talk video the next Friday. Have a good one, and I'll see you then.